Zeus screens light up justice calling from Sweden cold and Great Lakes falling. Educating fools, real talk streaming. Truth and laughter, crime redeeming. Raise your glass to law and jest. Trials not just pain and stress. Teach the world, grind the gears. Through the humor, through the tears. Michigan draw cutting sharp like ice. Swedish fire burns, truth precise. Shot of whiskey, sip of gin. Rules of justice we begin. Raise your glass to law and jest. Trials not just pain and stress. Teach the world, grind the gears. Through the humor, through the tears. Bang the gavel, crack the screen. Courtroom chaos in between. Wine and laughter, we all bleed. Streaming trials, feeding need. Layers of law, dealing truth bare. Laughs for a while, do we even care? Chip on shoulder, fear in hand again. Together on this shaky stand. Raise your glass to law and jest. Trials not just pain and stress. Teach the world, grind the gears. Through the humor, through the tears.
All right, and welcome back to Making Law Simple and Nick Starr dual stream of the Christopher Schurr trial. This is day 3 of the trial. Yesterday, we heard a lot of nonsense from some experts. We're going to continue on this morning. Oh, and Nick is joining us. Welcome, sir. Welcome.
Hey.
No, I thought you were going to watch. We're going to continue to watch that other case that's going on. I hear it in the background, by the way.
Yeah. Oh, this is good. Oh, yeah, this is good.
I was watching it a bit, and then I was like, "Yeah, we're gonna go live," but it is getting spicy. I'll go check it out.
Yeah, I mean, Jennifer McCabe lied to the FBI after being told by the FBI it's a crime to lie to the FBI.
Yeah, that didn't come out in the first trial.
No, it didn't.
Yeah,
this is the first we heard about, and her explanation is, "Oh, I forgot."
Well, first she tried to blame it on her not brushing her tooth.
Yeah,
and then so
yeah, so she contacted 5 people. She only told everybody about 2 people.
Yeah,
and she didn't tell them about the other 3 people she called in the 10 minutes.
Yep. Yeah. Well, it's the sewing circle. We're just mothers that call each other when things happen.
I mean, it's
yeah. She lied though. At the end of the day.
Yeah, and her explanations are so bad.
The question is really is the judge is not the judge, because we know where the judge is, but is the jury going to really think highly of this conduct and that sort of thing?
Well, there's one thing that caught my attention with this that might not be so good for the Karen Reed.
Yeah, what's
because before FBI, she had no recollection of I hit him. after FBI, all of a sudden she remembers I hit him.
Yeah.
That I don't know. It's an amazingly long timeline in it.
Right.
And it might be because she thought, well, I got away with it once, I can get away with it more.
Yeah, that case is all kinds of insane.
Yeah.
And yeah, Jennifer, her testimony is the most insane. It was the most insane during the first trial.
Yeah.
It seems like it's the most insane during this trial. Short of, we don't have Proctor on the stand now, right?
Oh, but we will have Proctor on the stand sooner or later.
Well, the defense is calling them, right?
Yeah, definitely.
So
now, I normally don't talk about how people look. I mean, fat, not fat, yeah. But I saw on AV to the 7th power somebody commenting on Jen McCabe with, have you ever pushed in the face of a Barbie doll?
You know, the way she talks and the way she looks, I said that I was in Rakita's chat, and I said that she looked like a crack whore masquerading as a housewife.
Yeah, those dental bills.
Yeah, she's all sorts of awful.
Yeah, okay, let me turn off that because this is so distracting. And hold on.
On to our trial. Welcome, Matt. Welcome, Gwendolyn. And we've got Dark Lotus in the chat as well. Welcome. If you guys are watching and not chatting, that is fine. I know there's quite a few people watching and not chatting, but no worries. We're going to continue and pick up on the morning, day 3 of the Christopher Schurr trial, where we left off sort of in the middle of cross-examination of the state's last expert witness. And who was that? What was his name? I don't know. He was talking really slow, and I'm excited to have him on Nicholas Bloomfield. That is BLOOMFIELD. So I'm excited to watch him on 1.25 speed or higher. Is that night in Sweden? It is currently 6 p.m. in Sweden right now, but Nick is getting into the time where it's never night in Sweden. The sun is always up pretty soon. So I think the longest day is June 19th this year, and we're almost to May, so the days are getting long. It doesn't get dark much there. But so we didn't have a whole lot of preliminary issues. They basically got into it, and we're going to pick it up first thing this morning. And I have it set at 1.25. Terribly slow like he was last time. I'm going to speed it up. And we'll go from there. I'll make myself step up.
Look at the video and still frames of the video, correct?
That's correct.
Why can't I see it on screen?
You can.
No, I can't.
Can everyone see it on screen? I see it. What are you looking at?
I'm just looking at.
All right, let me stop sharing and present again. Yeah, I was just looking and I didn't see anything. That was weird. I was checking our my feed. All right, how about now?
Yeah, there it is.
Okay, that was weird. What? There we go.
The taser. You have a problem with the taser being used, but it's how.
What do we have?
Schwarzbier.
And that's their assessment, yes.
Neuseller Schwarzbier.
Can you go over like, a little bit again? Why is this a bad? Why was this bad tactics?
So 2 reasons. Number one is the effectiveness of the taser. In order for the taser in these situations when there's a probe deployment that is being attempted by an officer, the greatest likelihood that neuromuscular incapacitation is going to occur is when the probe
Mom's in the chat saying no, and then yes,
large muscle
and then no
mass areas of the body And what taser is also recommended through their training to officers is what they term splitting the hemispheres, where if again you use the waistline or the belt line, separating the upper from the lower hemisphere, getting a probe in the upper half and a probe in the lower half of the body, again, give officers the greatest likelihood that neuromuscular incapacitation is going to be achieved. In order for that to happen,
this guy is testifying to all the wrong things, contrary to what the state's earlier expert testified to. Happy-go-lucky taser salesman guy.
Right now, down to now 5631. I think there's a laser point there too. Can you give them the dread what they're looking at here in terms of when you talk about the spread and what about tasers aimed at, if you will?
So right here, you can see two laser pointers, which are affixed to the taser device. This is to assist officers in being able to visually see where the probes are likely to impact. The green laser dot is the upper probe or the top probe, and then the red dot is the lower probe. Again, and they're different colors so that officers are best able to distinguish between the two. And again, so that's a visual indicator. So right here, you can see that both of the probes, based upon the laser sighting, are above Mr. Lyoya's belt line. And
he didn't want to get tased, Nick. He shouldn't have had to get tased because he didn't want to, not because of anything else.
What was the other issue then that you had?
Because he didn't want to.
With this appointment, it's not just the taser distance, but it was something else related to weapon retention?
Correct. So it's generally accepted in policing all across the country. The principle of what we refer to as weapon retention, where officers are taught tactics to retain their weapons, essentially to keep other persons from grabbing and getting a hold of their weapons and potentially using those weapons against either the officer or other bystanders. So this is a heavy part primarily of defensive tactics training that officers go through, both the basic training as well as they go through refresher trainings throughout their career. And so extending a tool in close proximity to an individual, especially one that is facing you in this manner, creates a high likelihood that your weapon is likely to be grabbed, or your tool is likely to be grabbed in this particular instance. What we see a lot of times, and again, this is not just related to tasers, this could be firearms, batons, OC spray, is that when it's in close proximity, you will have subjects who will reach out and attempt to either deflect or disarm officers just because the opportunity is there. Even if prior to that there was no indication that an individual was attempting to close distance. And
full disclosure, Nick and I went on with Andrew Bronca this morning and watched a lot of this cross already. But I don't understand it at all.
No, I mean, they are supposed to discredit him and make him say bad stuff about his testimony on direct examination. He just keeps testifying.
Yeah, the questions are really bad. They're open-ended. They're not they're not leading questions. There's no follow-up to bad answers. You know, if you ask him, you know, yes or no, and he pontificates for a half hour, there's no like, okay, so is it yes or no? You know, there's none of that.
And disarm an officer, it's more opportunistic in a lot of these cases.
And so that's what essentially happened here, because you continue on.
Hey, Derek, afternoon.
The weapon was grabbed right around 56, 58. 56, 70, you clearly see the taser in the hand of Patrick, correct?
That is correct.
Now, you didn't just look at this frame by frame, you looked at all the videos, correct?
All the videos were provided to me, yes.
This is going to exhibit one, the cell phone video.
Are we going to see this again? How many times are they going to show this? But this time it's the defense.
So what I heard there was what I would recognize.
Why would you want to
the sound that a taser makes during
keep showing it?
So you
it's
initially
the
hear
best
a pop, which is
evidence
essentially
for the prosecution.
When the cartridges, or excuse me, when the probes
video.
are leaving the cartridge of the taser, you'll get that distinct popping sound that you hear, followed by the cycling of the taser, which is consistent with kind of like consider kind of an electrical sound or an electrical cycle.
Continue on.
Okay, why you gotta do it up, man? He good, man. Let's go and change him. Let's go and change him. No, he good.
So did you hear anything there?
Again, at this point, I heard another popping sound that I recognize as being consistent with a probe deployment.
And just for the record, that's about 113 to 1 yard.
You can talk to him, bro.
My monitors are all messing up.
Stop grabbing him like that. Now he's good at it first. Yo, you hit him too.
Yep, he is.
Now he ain't got no taser. I see it.
I'm going to stop right there. Now, in terms of, did you ever hear any additional taser deployments other than the two you just mentioned?
No, I only heard the two. The other thing that I wanted to mention, just because you asked me about sounds, is with each taser deployment, you'll also hear kind of a chirping or beeping coming from the taser. These tasers, specifically this model, has built into its software to where it will cycle for 5 seconds automatically, then it has an automatic shut off. And so that chirping is notifying the officer that, hey, the cycle is coming to an end. And in both probe deployments, or what I recognize to be the sound of probe deployments, as was asked, you also hear the follow-up chirping notifying the officer that, hey, this 5 second cycle that is active is about to come to an end.
And that was kind of my next question. Did you ever hear that chirping at any point in time after that? Other than the two deployments, did you ever hear it, at this point in time or just before the shooting?
No.
So obviously you took a look, you saw the shooting now, you've seen this whole incident and, in your analysis of this case, correct?
Yes.
Could you tell the jury what your opinion is when a reasonable officer in the same circumstances made the decision to fire, as we just saw?
Or direct, I mean?
So
This should be cross.
with the taser,
Right.
there's a
Sounds
theory
good.
that's commonly
Correct. I
held
hope
within
it's
the
not
policing
cross.
industry
Yeah.
with regard to an officer.
I'm
being
not
disarmed with a taser.
entirely sure.
The theory essentially posits that an officer may
Because
be
if it is
justified
still a
in using deadly
direct
force if they were disarmed with a
object
taser
to
because
showing
of
that
a
damn video
threat
all the
that they may,
time.
have the taser used against them, specifically being incapacitated by the taser. In order for that to be a valid claim, the taser would have to be in a condition to where it could cause neuromuscular incapacitation. The greatest likelihood of neuromuscular incapacitation being achieved, as I've mentioned here on the stand multiple times, is through a probe deployment. The Taser 7 is equipped with two cartridges, and those cartridges are there because, again, over the years, the original tasers only had one cartridge. The taser started coming out, Axon started coming out with multi-cartridge models because, again, a lot of things have to go right in order for to have a good probe deployment and have neuromuscular incapacitation achieved. And so taser started again coming out with multi-cartridge models to give officers follow-up opportunities in the event that they were unable or unsuccessful. And so there's only two cartridges available. Beyond that, when it comes to drive stun mode, even with the expanded cartridges, we're now in a situation where the taser can still be used in follow-up or drive stun mode, but that operates off the principle of pain confinement, so it does not achieve incapacitation. And so in this particular circumstance, you have a situation where a taser is no longer in a condition to where neuromuscular incapacitation is likely to be achieved, either against the suspect or against the officer in this particular case. And so based upon that, a reasonable officer in this position to elect to use deadly force, knowing that is the condition of the taser, that would be unreasonable, excessive, and contrary to generally accepted police practices.
I know for the question, Ryan. Thank you.
I lost all the chat in StreamYard. This is really weird.
Good morning.
Okay.
Now
I asked you a couple of questions about your background.
Yes,
I think you said you work for a hospital system or a hospital
I do
team?
now, yes.
And what do you do there?
I'm the regulatory manager.
Okay. What do you do as the
No,
regulatory
this is
manager?
not his job.
So I'm
He works
responsible
for a hospital.
for making sure that the organization which I'm employed with is in compliance with federal and state regulations, primarily
Wait a minute,
the
he's an
regulatory body
expert on
in healthcare,
taser
CMS,
and best
Central
call
Medicare
practices,
Medicaid services, and so
and he doesn't
standards,
work with it.
The
He
hospital
works
No,
at
he-
a hospital
qualify for those monies.
as a
Compliant.
pencil pusher.
Do you ever review situations to determine whether or not
This is his hobby
particular
now.
situation, individuals comply with regulations or rules?
Yes, I do.
Okay. All right. And I'd like to talk about, really, you gave focus really on two opinions. One was yesterday, and you had a little bit of that today. And then you had another opinion, the one you just ended with, and I'm going to talk about those in order.
Okay.
Okay. So now you did team up with Professor
It's
Stoughton.
after 6 p.m. I'm
you
having
guys
a
have a
beer.
joint
Leave
report?
me alone.
Yes, we do.
All right. How do you know Professor Stoughton?
So Professor Stoughton now is a colleague of mine when I was conducting research for our organization when I was employed with the Farmington Police Department in reference to
Cold
the
here
contagious fire
today.
phenomenon. He was one of the
No, we
academics
had
that I reached out to, and,
21
we began,
degrees
to
Celsius
report
today,
from there,
which
and
is quite
then,
warm
that,
for
It's like
turned into
72
some professional
yeah, something like
stuff
that.
and,
Yeah.
working in this field.
Okay. All right. Thank you. So yesterday you talked about OC spray.
I did.
Can you tell us, OC stands for something?
That stands for oleoresin capsicum.
Now we know why they call it OC
pepper
spray.
spray.
That's correct.
Yeah, but
wanted him to use-
no. Capsaicin.
Is it something that a police officer might have? on,
Capsicum
his or her
is
Generally
the
speaking, yes, it's OC spray is
chili-
a common force option that officers are provided.
pause, please.
That is very
capsaicin is the active ingredient in chili. That is what makes you all hot and crying and hiccups and everything. The capsicum, that is the sub species of which because you have 5 different chilies. You have the capsicum annum, capsicum this and that. Yeah, five different. So no, OC does not stand for what he said it was, because it's not capsicum, it's capsaicin.
And Nick would know because he raises peppers.
Yeah.
common
Now-
throughout the industry.
Unless, because it's the United States, you...
Either way, he's saying that the officers should have used pepper spray.
Mm.
It's like, how are you going to use pepper spray in that scenario?
Okay,
Unless
so-
you're going to spray yourself.
So they actually call it oleoresin capsicum. Well, that is a really bad way of saying it, because since it's the active ingredient is capsaicin, not
Yeah, Google never
capsicum.
lies.
Oh, stupid mother.
You got to ask Gronk and see what Gronk says. Then you'll really know.
Yeah, but it's still wrong,
Yeah.
because
You wouldn't.
capsicum, could be an ordinary pepper, bell pepper. That's also a capsicum subspecies. I mean,
But he's the expert, Nick. He knows.
yeah, he also
Classified
looks
as
like a
a
penis.
deadly force.
No, I would not.
Okay. Now you were talking about it, but is anything in your opinions, or is it your opinion that because Officer Schurr didn't use OC spray, he acted unreasonably?
No, not in this particular case. Part of the use of force calculus is what reasonable options did an officer have. That clearly could have been an option that would have been reasonable based upon the level of resistance that a reasonable officer in this situation would have observed. But it didn't. It wasn't selected as an option in this case.
Okay. All right, and if we can switch over to the defense. And 5400. RFN 5400 from Defense Exhibit A. So I'm going to play you the part about the taser before the final use of deadly force. And it's not very long. We have a, I'm sorry, I have a problem with it. Well, it's gonna be connected.
Oh, let me get the closed captioning up higher.
And so this is in regard to the opinion that you finished up today, the taser deployment, the first one. We can just play that in normal speed. And this is RFN 5400.
Yeah, they keep showing the best evidence for the prosecution. But yeah, what do I know?
I don't think so. I don't think this is the best evidence. The best evidence is at the end. When
Yeah,
the
okay,
gun is
okay.
played.
So when you're talking about
that freeze frame
Officer
at the
Schurr's use of the
end.
taser, you're talking about
Yeah.
those seconds in that video.
Yes.
And so you would agree that this happened over the course of reaching for the taser was a matter of seconds.
I agree with that.
Okay. And it's your opinion that using the taser in that situation is fine, but it's the manner in which you used it was not fine.
That is correct. The taser as a force option was reasonable. However, the manner in which it was deployed was technically unsound.
And part of that is because of the distance, and because you didn't believe that there was
This is not good, Cross.
the ability
No.
for NMI at that distance. Correct?
Not the ability.
Do you think it wasn't appropriate to use this the way it was used because of the distance? Now, what if I told you that the manufacturer of the taser sat up here and testified that the distance was fine, that it could still cause the impact? Would that change your opinion, sir? No, it wouldn't. Okay, so you're going to go ahead and go against the manufacturer's recommendation and testimony.
Yeah.
That's how you do the cross, right? Let's see if he gets there.
But the likelihood, based off manufacturer recommendations, that NMI could be achieved was significantly diminished.
Okay, and I think you said yesterday that the preferred range is 7 yards. Did you mean feet?
No, feet.
Okay.
Yeah, sorry.
I didn't think you meant 21 feet, but
No.
we did make you testify right after getting on
Yes.
off the plane. So, all right, so 7 yards you believe is the preferred range. So you get 12 inches or 7 feet. Did I just
Yeah,
say
7
yards?
feet. You
I'm
did.
sorry.
I was going to correct you, but you're fine. So, yeah, no,
Please
you're-
correct me if I do
No,
something
no,
wrong.
you're good.
Okay. So 7 feet would allow you to get 12 inches of NMI.
Generally, of spread, generally speaking, but in addition to that, taser recommends that those probes split the hemisphere. So you have, one probe, just as you're demonstrating, one above the waistline, one below the waistline.
So you
is
saying,
your
sir,
opinion
that
that
you
this
wouldn't
isn't
be
close enough to
scared and
split the
reaching
waistline?
for your
It seems like it's
taser
pretty
if
close.
you
It's
were
pretty
in
close
this
to the top.
officer's position?
Again, I'm speaking, it's close, but however, I'm speaking to taser's recommendations. So
Okay, and with regard to those recommendations, with the Taser 7, the actual recommendation to get the 12-inch spread is 4 feet, right?
is
4 feet?
4 feet?
Yes.
Could be.
Okay. So
Yeah,
it's not
yeah,
7.
I don't recall specific, 4 to 7. So yeah, somewhere in that range. There's not.
So he
yes.
says that 7 feet
So,
is
strict.
no.
Well,
that's
and
too
in your
close,
report,
but
you said
the
7 feet as well.
manufacturer's recommendation
And
it
you're
starts
basing that
at
on
4
the
feet.
trainings that you reference in your report, right?
And he also says that even if it's closer than that, it doesn't necessarily diminish the capacity to do the body immobilization. It just depending on where you hit, right? And he emphasized the stomach. He said we took the chest off, and obviously if you hit him in the arm, there's a lot less muscle there, so it's not going to really do anything. But if you hit him in the stomach, even if it's that close, it'll still immobilize him. And we're going to see the video. I don't know if we saw it already or if I'm having flashbacks to Bronca's stream, but you see the target and it's on the belly, and it's maybe 9 inches apart. According to the manufacturer's testimony, that would be enough to immobilize him.
Yeah.
So you want to go against all of that, sir? That's the question, right? That's never asked.
Yeah, but the defense needs to ask or lead into that question. Did you know that the manufacturer was here yesterday just before you and said this? I mean,
Watching 2 trials at the same time. Yeah, it's a challenge.
Yes, so Taser does provide trainings to departments. Anytime officers undergo Taser training, they actually do not, they may have their additional curriculum, but Taser actually provides a curriculum for officers that they recognize as the curriculum that officers essentially would need to go through for the manufacturer to recognize them as a valid operator with their device. And again, they put that out.
One of the people who actually holds those trainings
all the information that I
were on
referenced
the
in the report.
stand yesterday.
If it was 7 feet in the report, that would come directly from
And
Taser.
he said
Okay, and
that
you're
you
referring to
are wrong.
particular trainings on the Taser 2, right? In your report?
I don't recall specifically. Does it stay in the
Folks,
report?
this is why if you
Taser-
can afford it, you hire an independent attorney. Even if you're union based and we can provide you with legal help and attorneys, sometimes it's like the public defender's office. A lot of them are good. A lot of them aren't.
These guys are very technical. They're not showmen. And at a jury trial, you need a showman.
Yeah. And I mean, that is one of the things in the union that we are really, because we are very, very used to these law. You have best practice, you have company policy. Everything gets really technical, and everybody at the table knows what everybody is talking about because everything gets so practical or technical. Here you're in front of a jury.
You are, and I'll get back to Matt's question in a second, but I'm still hung up on the sentence structure of these questions. Well, essentially, he's on cross-examination. He's being asked to reiterate his direct examination, which is poor cross-examination. You don't want to reinforce all the bad things that were said on direct. You want to attack the credibility of the bad things that was said on direct. Don't just ask him an open-ended question that allows him to repeat himself, because all that does is reinforce his bad direct testimony to the jury. And taser is a brand name. It's like Kleenex or Band-Aid. It's not, the product is an adhesive bandage, but everyone knows it as Band-Aid, right? And that's the same thing with the taser or rollerblades or whatever.
Have you ever worked at Axon?
No, I have not.
Okay.
Yeah, the officer was being thrown around quite a bit.
Now, in a close proximity situation, let's say you don't get the full 12
Was
inches.
the officer being thrown but into
Are there any departments
was he using
that
knee
train
strike?
that you can use the?
Oh, I think he was trying to use knee strikes. I think that's the testimony that came out. That the officer was. Remember, we saw that promo or the graduation video where they were doing the knee strikes, and so I think that's the technique he was trying to do.
Yeah, with limited success.
With very limited.
Drive stun to complete a circuit of more than 12 inches.
Yes.
So if one probe goes in and another one misses, all right, sometimes that happens, right?
Yes.
You can just make a
More
third
often than
point
not.
The taser sales guy was much more fun to
because you
listen
have two
to.
darts basically going on, and they're designed to
This
actually
guy's so
spread the
boring.
The
distance.
12-inch spread.
So you can make the third point and cause NMI.
Yes, you could.
Hey, can you pin my stream?
Oh,
I didn't get a chance to do it yet.
Okay, and then I think you testified that in this situation, he should have created more distance, preferably 7 feet for you, right?
At least enough distance in order to get a reasonable spread that would split the hemispheres.
Okay, but there are some situations where officers
a
really
reasonable
can't
spread
create
to
distance,
get those
right?
12
And one is
inches.
if you're in a confined space,
Correct.
there's nothing you can do. You can't go through a wall.
Correct.
But that's not the case here.
No, we are adults. There's nothing
And also
funny
when
or
a
innuendo
suspect is
about
closing
spread
in on
and
the
12 inches.
officer, right?
Yes.
Okay. And is it your opinion that Mr. Lyoya wasn't closing in on Officer Schurr at
All
all?
right, I'm putting a poll up
Correct.
in my
In the
chat.
video.
Does the state's expert
that we
need to be
reviewed,
tased?
the one that's been shown here today, you can see that Mr. Lyoya's posture is always trying to create distance from the officer, and the officer in this case is the one who is closing the distance.
How about when Mr. Lyoya grabs the taser? That's not closing the distance?
At that moment, Mr. Lyoya, at that moment in time when the taser was presented, reaching forward, I wouldn't necessarily constitute, is closing the distance. He's reaching forward to grab the taser. I would agree with that. But the whole reason why that opportunity even occurred was because the officer in this case is the one who closed the distance on Lyoya.
But it doesn't matter. It's illegal for him to reach for the taser.
He didn't give him the taser though, right, the officer?
No,
Okay. Mr. Lyoya grabs the taser.
correct.
Is reaching out to grab something off an officer an act of aggression?
It could be. It's also consistent again where individuals are simply trying to defend themselves from being, in this case, having a taser used against them, being shot. There's a number of.
So it could be aggressive or it could be self-defense. That's what he just said. Well, in this situation, is there anything to indicate that Lyoya has the right to defend himself? No, because he's committing a felony by obstructing and fleeing an officer who's trying to detain him.
Yeah, it would be really interesting to hear those exact words, but in a different scenario where the suspect reaches out and gets a hold of a weapon. I mean, and subsequently fires it. What would he have used the same words? It was almost self-defense. He was defending himself against the gun or the taser. Well, he took it from the officer and then he shot the officer. Do you still claim he had the right to do it? Because that is what it sounds like.
I wonder if that question is going to be asked.
Reasons, and I don't know the mind of Mr. Lyoya.
Well, just based on the video, you agree that it could be an act of aggression for someone to grab a taser from a police
Correct. It
officer.
could also be an act of defense. Yes.
Okay, and an act of defense like deflecting something, right?
Yes.
Okay, how about disarming a police officer? Is that an act of aggression, in your opinion?
Yes.
Okay.
That's good, because that is what happened later on when the officer
Now,
actually lost
you and,
control of the taser.
Professor Stoughton
Yeah, but this
had some opinions
this
about
witness contradicts
um,
himself on redirect.
things that happened
Yeah.
That very statement. Stupid.
more than a minute and a half before deadly force was used, like chasing Mr. Lyoya around the car.
Yes.
And
Yes, I would be
I
as
talked a
well.
little bit about it
Stephen.
yesterday, and
I'm very
Professor Stoughton
confident.
talked a
in
lot
that.
about it. Is the fact that, in
Oh,
your
yeah.
opinion,
There's a reason
Officer
why
Schurr shouldn't have
the 10 to 2 at the traffic stop,
Mr. Lyoya,
you grab it, you
does that mean
hold it
that he
until
no
you're
longer
permitted
can
to
use
do
deadly force at a
anything
later
else.
time?
Imagine this was a
He's
10 to
still-
2 situation,
he's reasonably in fear.
and he's like, oh, that's a nice thing, officer. Can I hold it?
I know.
I mean, no, that doesn't end well. But according to this expert, oh, it's reasonable. You saw he was having the taser in his hand. Of course, you should reach out for it. I mean,
to hear that it's not aggressive. I know this guy's just saying whatever he wants. I gotta speed him up. Let me know if he's too fast.
he's a hired gun. That's it.
Yeah.
Of great bodily harm.
But even hired
he
guns
can-
can be effective
something like
if the
He's reasonably fair. He
defense
can still
doesn't
use
ask the
deadly
right
force, right?
questions.
So I'm going to clarify just a little bit. In order for an officer to be justified in the application of deadly force, they must be able to articulate why they have a reasonable belief that they themselves or another individual is under immediate threat of receiving great bodily harm, great bodily injury, and or death. by
That's
the
generally
actions of
accepted police practices, right?
another. And that is the language the Supreme Court uses, which is what was adopted by the policing industry and has now become generally accepted police practice.
And to be clear, you're talking about the U.S. Supreme Court,
That is correct.
not the Michigan Supreme Court.
That is correct.
Okay, because you're not familiar with Michigan law.
I'm not.
Nobody's familiar with the
wait,
law
wait.
that's actually being applied to this case.
Wait.
Um,
Wait. So he's there to talk about best practice and statutes and stuff as an expert, but he does not know Michigan law.
Doesn't know Michigan law. He's there to talk about general practices. He's not even there to talk about practices. Well, he did offer an opinion that Grand Rapids Police Department policies complied with general best practices. But general best practices is not the measure to which we're supposed to judge this officer's conduct. It is lawful conduct.
Yeah.
And if he doesn't know the law, he can't testify to the lawfulness of the officer's conduct, right?
Yeah.
So why is he even allowed to testify? Why was the last witness allowed to testify?
Yeah, I don't know.
Officer Schur's use of deadly force. He said it's unreasonable and contrary to generally accepted police practices. And I understand that the basis for your opinion is that the taser wasn't in a condition to incapacitate him.
That is part of the reasoning, yes.
All right. And I think you testified about it. You can hear the pop, right?
Yes.
Okay. And you know that there's two probes, right?
Yes.
Okay. Now I believe you testified about, it's generally accepted that in the absence of physical ability to incapacitate the officer or otherwise render him unable to protect himself, no reasonable officer, not one, could have concluded that Mr. Lyoya presented a threat of death or great bodily harm. That's what your opinion is?
Under these, the specific case, the specific fact pattern, yes.
Okay. And the reason you're forming this opinion is because you know that if an officer is incapacitated, he's lost the ability to protect himself, right?
That is the theory, yes.
Okay. And we're talking about what he reasonably believed in that situation, right?
Not what he reasonably, what a reasonable officer would have concluded.
Okay, so you're
Yeah, I just got to point this out. This is at 0.15 speed, or 1.5 speed. And this sounds normal. It's so slow in real time. So slow.
just talking about objectively reasonable officer standard.
That is the standard, the only standard in the review of all cases that's accepted in the industry.
Okay. Generally accepted.
Yes.
Not talking about Michigan law now, right?
Not
Doesn't
about-
he look a bit like the main
So you don't consider whether or
corrupt
not
one in
the arresting officer in
the
this case,
Shield
Officer Schurr,
TV
knew the
series?
second probe.
He does.
So when we review
Bronca
cases, we do take into
mounted
account
him
the
to,
subjective,
was it Groot with
statements,
the minions?
opinions of
Yeah.
officers, as far as, to fill in what a reasonable officer in that officer's situation would have known at the time.
Did you review Officer Schur's statement?
Does he have tiny legs?
Yeah.
And there it
Got
said
to see him stand up again.
This is hearsay. He can get it in. I can get it in if I want to. It's the same against party opponent. He can't get it in.
I believe the expert relied on it in his opinion, so I about that.
Okay, so I want to back this up because this is important, and I want to point this out.
Oh.
What he's being asked about is, did he take into consideration any of Officer Schurr's statements when forming this opinion? Because first he said, well, I included the subjective view of Officer Schurr. All right. Now it's supposed to be just an objective standard, but he's using subjective now. So then he asked, well, did you take into consideration any of Officer Schurr's subjective statements, right? His statements.
Okay. And in there it said that he.
I get it in if I want to. It's the same against party opponent. He can get it in.
So the objection is that it's hearsay. You can't get in hearsay. Right. Hearsay is a statement offered for the truth of the matter asserted. So, an out of court statement. So generally you can elicit statements of your own client, right? In the question.
Yeah, but he's not asking about specific statements. He just asked about, did you listen or take into account?
He was going to get into the specific statements, but here's why it's not hearsay. Because hearsay is admissible when it is used as the basis of the expert's opinion. So if hearsay is used to form the opinion that the expert is testifying to, then it can be admissible. And it's specifically in the court rules that says that you can use, because it's not offered for the truth of the matter asserted. It's offered simply to offer the factual support for the expert's opinion. So it is admissible. But the objection is that it's hearsay. You can't admit it. Can't talk about what Officer Schurr said.
I believe the expert relied on it in his opinion, so I'd like to ask him about that.
Well, you can't. It doesn't make hearsay.
Yes, it does, Judge.
Well, there's a lot of what hearsay that he's talking about.
What he based it on, but you can't say my client said.
He is asking what it's based on.
Whatever I said, that it would be hearsay. So I'll sustain the objection on that basis.
Okay. So with the judge's exception, you can't say specifically what your client said, but you can ask the expert what he's basing his opinion on. So my next question would be, okay, so what statements that Officer Schurr said did you take into consideration? That should be the very next question, right? Based off of the judge's ruling.
Yeah. Somehow.
Mr. Bloomfield, you relied on a lot of materials, including trading materials, right?
That's not the question he asked.
Nope.
He just lets it go.
Nope. Just lets it go. He doesn't know how to come back from that. And he was like, all right, let's just go into the training.
That's why you have to listen to the specific wordings of the judge. Yes. Is there a loophole?
Yep. The judge isn't going to give it to you like Bev does.
Is there a 12-inch spread in there?
Yeah. So, but you got to listen. You got to be able to think on your feet as a trial attorney. And I don't know this attorney. I don't know if he's the same attorney that handled all the interlocutory appeals and stuff. He sounds like a very technical attorney. But that's something that he instantly should have picked up on. You want to get your client's statements out there if you can. Even if it's not offered for the truth of the matter asserted, the jury can hear it. And then maybe you don't need to call your client to the stand. So to the extent you can, you push and push and push, and you get it out there.
Yeah. And you ask the question another way. Yeah. Objection, sustained. Ask it another way until the judge say, okay, you need to move on. But you still have that in the head of the jury.
And it might be a trial tactic to not get your client's statements out there, but he clearly was asking about it, so he clearly wanted the statements out there. So ask it a different way.
We did rely on some of the training materials that were provided, yes.
And you said you considered the statement as well, from your opinion?
Yes, we did.
Okay. So I believe you testified yesterday about incidents where if an officer is incapacitated and loses his firearm, he can be shot or killed, right?
I don't recall getting into that yesterday. I did touch on that briefly today.
Okay. Are you aware of situations where an officer is incapacitated and then loses his firearm and is shot and or killed?
So I need a little clarification there. When you say incapacitated, are you talking incapacitated with a taser specifically or incapacitated by other means?
Well, let's talk about both. Okay. Incapacitated by any means. Are you aware of any situation where an officer has been killed after being incapacitated?
Yes, there are situations where I would personally classify that an officer has been incapacitated. Maybe that would mean being knocked out, being injured to a point where they're no longer able to successfully defend against somebody disarming them. I am aware of incidents like that.
Okay. And here the concern is with a taser, you could be incapacitated if NMI occurs, right?
Yes.
Okay. Are you aware of incidents where an officer has been tased and has been shot?
Where an officer has been tased and then shot. It's a very specific circumstance. Right now, I'm not aware of anything. Myself and my colleague, Professor Stoughton, him specifically, conducted extensive research on officers killed in the line of duty. And we are not aware of any case or instance where an officer had a taser that was used against them where they were incapacitated. And also within that same set of circumstances, it resulted in an officer's death where they were disarmed. In addition to that, I do not know of any case, not including deadly force, where officers have been disarmed with their tasers where an officer has been successfully incapacitated by a suspect.
You're not aware of that, right?
I'm not aware of that, and nor in any of the research that we conducted in preparation for this did we ever find anything that would essentially change my opinion. If I was aware of at least an instance, I would let you know.
Okay. I'm just asking you about what you're aware of and what you rely upon. Now, your opinion states that it's unreasonable for Officer Schurr to believe he could be incapacitated, right?
For an officer, yes, in his circumstances.
Because available evidence establishes that any reasonable officer in Officer Schurr's position would have been aware that Mr. Lyoya did not have the ability to incapacitate Officer Schurr because both of the cartridges in Officer's taser had been discharged. Is that right?
Yes.
Okay. So it's unreasonable for Officer Schurr not to have known that the second cartridge had been discharged?
I believe what we stated in our opinion is that an officer in these circumstances would have known that both cartridges had been discharged from the taser.
Okay. And because you assume he
on
would
that
have known,
kind of stress,
therefore
officer?
unreasonably believing he could be incapacitated by the taser.
Correct.
Where
You also have stated that in stressful
where
environments,
suspect
human
is
decision-making
having
suffers.
a hold of your
Officers may
taser.
experience distorted sensory perceptions, including visual
This is-
distortions, like tunnel vision, auditory
not-
distortions, such as auditory blunting,
Dirty Harry.
and temporal distortions.
Now ask
Receiving
yourself
events
one question.
occurring more
Did
quickly or
I
more slowly
fire
than they actually
5
are.
or 6?
Is that a fair statement?
Yes, it is.
In fact, you said it right?
Mhm.
Yes?
Yes.
Okay, so what you talked about auditory distortions there, and for example, auditory blunting. What's auditory blunting?
So again, it is a term that is known in the industry. Auditory blunting or auditory exclusion is what they're most commonly referred to. So essentially, that is a phenomenon, physiological, psychological phenomenon, where under stress, when officers have discharged their weapons, they report that essentially the signature of the weapon being fired, the sound, is reduced. And that has led officers to believe that in some cases that something is wrong with their weapon as a result of that. And so, again, this is a pretty well-known phenomenon. Most officers receive education that if they are involved in a deadly force encounter and they discharge their weapon, that a lot of these physiological and psychological phenomena may be experienced. Auditory exclusion happens to be one of the most commonly reported phenomenon that is experienced along with tunnel vision.
And what's tunnel vision?
Tunnel vision is essentially where officers, and again, this doesn't just have to be officers, it could be soldiers, but in deadly force encounters, they become hyper-focused. Essentially, their vision, they report what could be termed as superhuman vision, where they're able to hyper-focus mostly on weapons at far distances. Officers have reported being able to see amazing things. Also, time distortion, where generally speaking, among most officers in deadly force encounters,
Talk about
they
the
report
super
time as
nose
it's
who
slowed down.
can detect
Rarely do we hear any
marijuana
reports of time speeding up. Some
on the
but most cases
freeway.
slow down.
Okay,
Three
these
cars
phenomena occur
away.
in stressful environments.
in 70 miles an hour.
They can. Their most common reference is in when officers are actually under the threat of receiving great bodily harm, great bodily injury, and/or death, and responding to that threat, primarily with deadly force. And so it's just not all stressful situations. In general, officers encounter stressful situations all the time. The majority of the literature and the research is specifically around deadly force encounters, specifically when officers are under the threat again of great bodily harm, great bodily injury, and/or death, and are responding to that threat to defend themselves.
Is the video that you just saw one of those types of stressful situations where auditory blunting could occur?
Generally, the situation is pretty common in policing in terms of the.
See, there's such a better way to ask that. After you've watched that video, you would agree that this is one of those situations in which the auditory blah, 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 blah could occur, right?
Yeah, or split it up. Would you agree that not obeying to a lawful order, would that be a sign of aggression? Would you agree that running away is not obliging to a lawful order? would you agree that once apprehended or caught up with, resisting, is that an act of aggression? I mean,
Right.
take it into bits and parts, and then go. So
But
all of this you actually agree on? Yes or no?
Yeah. Walk him through it. Walk him through it with affirmative statements that he can't possibly disagree to, because he would sound insane if he did. And then just start. All right, so you disagree to all of these things.
Yeah.
That's what needed to happen here.
Why,
That's the trend.
Dave? Can you help me with?
No.
I feel like I could be a public defender in the United States. I mean,
to be fair, we don't know where these defense attorneys came from. We don't know if they were hired by the union, if they were hired by an insurance policy that he had. We have no idea.
Yeah.
Expired.
Or if they were
as
public
far
defender.
as now, when you said that statement, and correct me if I'm wrong, is it possible? If you're saying is it possible, well, I'd have to concede that anything is possible. Is it plausible? No. And the reason why I say that is because there's nothing in this situation that I would term that an officer in these circumstances would have a reasonable belief that they were under immediate threat of receiving great bodily harm, great bodily injury, and or death.
Well, we just talked about the fact that you had formed an opinion
Yes.
that if Officer Schurr had been incapacitated, he could be harmed or die.
Yes.
And then you gave us your opinion that he wasn't in the situation because he didn't hear the second probe, right?
State that one more time.
Let me ask this a different way. Are you an expert in auditory exclusion?
I am not.
Okay. All right, so we talked about incapacitation. What you don't talk about is whether or not do you have an opinion on whether or not the drive stun can cause bodily harm in a situation where a person has taken an officer's taser, as in within a foot or two of the officer?
So when you say bodily harm, can you give me a reference by what you mean with bodily harm?
Like being blinded,
Harm to the
or
body.
getting hit in the throat and the trachea collapses.
I would assume that those things could be possible with that taser and drive stun.
Okay, so in a situation such as this, where the taser is close to the officer, is it reasonable for him to fear that he could be harmed in those ways, given the situation?
Again, it's possible, but anything is possible. I didn't see anything in the facts of this particular case that would lead me to believe that a reasonable officer would have felt that that was an immediate threat at the time deadly force was applied.
Well, Mr. Lyoya in this case had switched the taser from his left to his right hand. You're aware of that, right?
Yes.
Okay. And he had it in exclusive control over it in his right hand, right?
When you say, again, exclusive control, I don't know what you mean by that. His hand was on the taser. He never had his hand in what I would term as fire control, or in the way that an individual would commonly hold it to activate it to cause either drive stun in this case.
How do you know that when
Does that
you
make a
can
difference to you
see
if
it?
Mr. Lyoya was holding it like a gun? Would that change your opinion?
It would influence my opinion. I've had cases where that has been circumstances.
So, Mr. Expert Dude, let's walk through this video. Where do you see it? Can you see it? You can't see it, can you? So your opinion is based on assumptions. And then move on, right? But I don't think we get that. I think he's done here. Horrible crime.
One opinion, you said, one of his questions was that, well, your opinion is based on the taser's not in a condition to incapacitate him. And you said, well, that's part of my opinion why the use of force is not appropriate here. What's the other part, I guess? What is missing out of that opinion? It's not just the taser. What else is there?
So when we talk about any application of force within policing, it's based upon a number of factors. One is proportionality to the resistance or threat that an officer perceives. During this entire instance, well, I talked about the other applications of force that a reasonable officer would have used throughout the situation as it unfolded. The primary form of resistance that was demonstrated by Patrick Lyoya would be classified as resistance. And so resistance in the form of physical resistance, attempting to get away, being taken into custody, creating distance. Not at any time in any of the evidence that we reviewed did we ever see Patrick Lyoya attempt to harm the officer in this particular instance. As noted, Patrick Lyoya did grab a hold of the officer's taser, and there was a struggle over the taser in this instance. But again, in this circumstance, it is that there was nothing that we
Doesn't
termed
need
to
to
be
attempt to
aggressiveness
harm
or
him.
combativeness on the part
He
of
just needs to be
Mr.
in a
Lyoya towards the
position
officer
with
in
an
this case,
opportunity
coupled
to
with the
do
fact
it.
that the taser is not in a condition where neuromuscular incapacitation could be achieved, in addition to the fact that a reasonable officer would have known that that was the condition of the taser. And so all of those things together would lead a reasonable officer to conclude that they do not have grounds to reasonably articulate that they were under an immediate threat of receiving great bodily harm, great bodily injury, and or death. Therefore, that classifies the application of deadly force in this instance as unreasonable and excessive.
Thank you. Any proof? Any more questions on that?
So does the officer have to wait to be harmed before he acts?
They do not.
Okay. And it's your opinion that you never saw any act of aggression by Mr. Lyoya on those videos?
No.
That's not your opinion, or you didn't see it?
My opinion is that we did not see any.
Why
action
would
by
you
Mr. Lyoya
ask that
would constitute
again?
act of
Why
aggression attempting to
reinforce
harm the
that?
officer.
Just stop with the first question.
I guess.
I know, figure out.
Well, to be fair, Gigi, I think that's what Nick and I are doing. So I'm not going to call him out too much on armchair quarterbacking.
Yeah. We are in the comfort of our homes, having a beer. I highly doubt the judge would allow this kind of setup.
Yeah. I was noticing that yesterday. Somebody said armchair or Monday morning quarterbacking, and I was thinking, yeah, I feel like I'm doing that now. But I'm gonna still offer my opinion. All right, so we have a jury question.
Finally, you request.
I ordered new camera cables. I'm hoping they come today because I see my camera glitching out. This is a new camera setup where I can zoom way out. Maybe. I like this. Oh, little sidebar. Okay, here we go. See, I can zoom way out.
Do you find errors on the other's choices of force or lack thereof?
I don't know if I'm fully I can grasp what the question is.
Manual zoom in.
Can you read it one more time, Your Honor? No.
When investigating cases, do you usually find errors on the other's choices of force or lack?
When investigating cases, do you usually find errors on others' use of force or lack thereof? Which is a really bad question because I don't really understand what it is. But what I think the jury is asking is, do you often find errors? Like every case you interview or that you investigate, you always find errors. Yes or no? Essentially is what they're asking.
Thereof.
So
yeah, you often testify for the
investigating these
defense
types
or the
of cases.
prosecution. That's about
That
it.
that wasn't asked. How much he's paid to be here today doesn't ask. I know we talked about the pay thing isn't really a big deal, but how often do you testify on behalf of the defense or behalf of the prosecution? Those sort of things would be interesting to know. Not any question about the case, but question that's relevant to their testimony and appropriate. So they couldn't ask questions that are outside the scope of this witness's testimony, and they can't ask things that would be inappropriate. Like, did you talk with plaintiff or with the prosecutor beforehand, and what did they say? You know, things like that. That might be work product, and it would be inappropriate to ask that. So just about anything.
I think if I'm understanding the question correctly, the question is do we often see errors on the part of officers in their decision making and the levels of force that they choose to employ? The answer would be yes and no. In a number of cases that myself and my colleague in this case, Professor Schurr, we basically review hundreds of cases, and in cases we find where the actions of the officers are completely reasonable and consistent with generally accepted police practice. In other cases, we find the opposite, where none of the actions of the officer were reasonable and consistent, and then we find a mix, where sometimes some of the actions of the officers were reasonable and other actions were not reasonable. In this particular case, we rendered a number of opinions on the actions of a reasonable officer in these circumstances that we found to be reasonable. Most of that was leading up to the deployment of the taser. We said, hey, we recognize that the majority of these decisions by a reasonable officer in this case were reasonable decisions and were consistent with generally accepted practice. And so I hope that answers the question.
And the follow, Your Honor.
On the jury, may this witness be excused?
Your Honor. Your Honor.
Thank you very much.
Thank you, Your Honor. Actually,
Oh, we can't see his legs.
Oh no.
The defense
We-
or the
we-
state's rest.
Oh wait, that was it. The last.
That was
This
the
guy
last
was-
witness.
That guy
That
was
guy.
the last witness.
Yep.
Oh,
11 witnesses, 3 experts. Now, you should be absolutely convinced beyond a reasonable doubt that this guy is guilty.
and it's not self-defense. Well, that is
And that it's
implied.
not self-defense. Yeah, that's true.
Yeah,
it's not
yeah,
self-defense.
Is this beyond? Have the prosecution prove to you beyond a reasonable doubt that this is not self-defense?
Right.
And even if you say no, I'm not 100%, I'm not beyond reasonable doubt, you still also have to say, well, did they prove their case
Yeah, did they prove
beyond
their
a
case?
reasonable? So you have twice beyond reasonable doubt, and you
So-
should be completely convinced.
I'm convinced that the state thinks that the video is enough because the
Yeah.
video is enough for me, to be quite frank.
Yeah, it's that final split second.
Mhm.
That is where it's, because for me, that split second or half a second, because he's on his back, pushes himself up while pushing down the head into the ground, grab his gun. That's a lot of different movement, and in which he has to take the conscious decision. First, I'm going to shoot him, and I'm going to shoot him in the neck.
The video proves the case. I agree. I don't think the state had to do much more of anything than to play those videos, to be honest, to get beyond a reasonable doubt for me. Now, the last 2 witnesses, I think, are complete BS. And I hate the state for bringing them.
Yeah.
But that's a personal opinion.
Yeah.
If I'm looking at this objectively, thus far, I think the state has met their burden. Just because
Yeah.
the videos alone.
Yeah, the video. And now, if you guys aren't convinced, you still have this. The defense sometimes screws up and proves the case for the prosecution.
Mm-hmm.
So,
well, let's. So the state rests, then they go on break, and
Yeah.
then we come back to oral arguments regarding a motion for mistrial and a motion for directed verdict. Now,
directed
or a motion
verdict, it is not.
it is
But
not.
the-
They've met their burden. So the directed verdict, the judge very clumsily goes over the elements, which is basically you need to view all the evidence on
In the light most favorable to the prosecution and yada yada yada.
yeah, and determine whether or not a reasonable fact finder, in this case the jury, could conclude that there's reasonable doubt or that he's guilty beyond reasonable doubt.
Yeah.
And so that I don't think is going to stand. But they bring a motion for mistrial because of these last 2 witnesses. And this I didn't get to hear the whole thing, and I'm excited to hear this.
Okay.
I'm going to slow this down. Do 1.25.
Your Honor, good morning. So at this time, the defense will be moving for a mistrial based on the evidence that has been presented so far. This is based,
This trial?
yes. And this is based on the evidence that was presented in the prosecution's case in chief. And we believe that the evidence presented will prejudice the defendant to the extent that the fundamental goals and accuracy.
This I
accuracy
agree
and
with.
fairness are threatened by allowing Mr. Stoughton and Mr. Bloomfield to opine on standards that are not applicable under Michigan law. As they both admitted, they don't know what Michigan law is, and that are not within the knowledge and in the situation of the arresting officer, based on tactical considerations that are not ultimately at issue in this case, including everything that led up to the ultimate issue here, which is whether Officer Schurr has an honest and reasonable belief.
She needs to quit reading
Fear
stuff.
of aggravated serious bodily injury at the moment that he made the decision to use deadly force. We also, based on their testimony, it's clear that they have not relied on
I'm
proper
dropping
training.
stuff.
They were relying on outdated policies. They were testifying about a taser model, an old taser model. They were not qualified as taser experts. and they gave opinions, several opinions about the taser. And at this point, we believe that we're too far along with the jury to simply strike their testimony, because they have heard testimony from two of people's experts now that do not accurately, and are not nowhere near based on what the law is in Michigan, and what should be considered in whether or not Officer Schurr was justified in using deadly force. And so at this time, we would move for a mistrial on that issue. And if the court is not inclined to grant a mistrial, then we would be asking that the testimony is struck from the record.
Mr. Jingles.
Although we don't think that would be enough, because they've heard too much.
I
now based on
100% agree with the mistrial motion.
And under Supreme Court precedent, San Francisco v. Sheehan, the 2015 case, even
Mr.
under the Fourth
Jingles,
Amendment, that
was in a fight and he
districts the situation,
got a
the court
piece
did
of
not
his
establish a
ear
Fourth Amendment violation, merely
clawed
on bad
off.
tactics that result in a deadly confrontation that could have been avoided. Courts must not judge officers.
But he still won the
on
fight.
conditions of hindsight. And they're quoting Graham versus Connor strategy. So we'd be moving for a mistrial on those grounds. And alternatively, we would also be moving for a directed verdict based on the motions that we just filed with the court. Given the complexity of the case, we would ask the court to review the written motion that we filed before making a ruling on that and before we move forward in our case in chief.
Mr. Rucker?
We haven't got any motions, that'd be nice if we got one too, but I think there's no reason to grant this trial because they talk about objective reasonableness. Of course, we talked about this over and over again in chambers that like objective reasonable officer, and we made sure to stick with that standard with the testimony of the experts. So there's no basis. And the experts can't talk about Michigan law. The law's up for the judge to instruct on. So to say they weren't talking about the law, that's not their role to talk about the law. That's the jury's role in terms of determining whether somebody's engaged in self-defense, and that's a question for the jury. So they stay away from that. There's definitely no grounds for this right now.
Anything else? Ms. Middleton?
The only thing I would add is while they were testifying, they were talking about the laws and policies from other states. They were talking about what applies from the International Association of Chiefs of Police. They talked about all of these other agencies from New Mexico and South Carolina that is not grounded or not required under Michigan law. And we outlined that in our trial brief with an attached 4 declarations explaining that that is not something that Michigan law requires or that DOD trains their officers.
Anything else?
No, Your Honor.
Mr. Rucker? Okay, so, I mean, I'm prepared to rule on the motions for both mistrial.
Of course she
and
is.
verdict, which incidentally, as soon as we left the courtroom, I did receive the motion, I did review the motion, and I'm prepared to move forward on those at this point. I still give you a break if you want after, but as far as the mistrial is concerned, I do not believe that the expert's testimony rises to the level of requiring a mistrial. I believe that the fact that they were testifying, they clearly were testifying on generally accepted police practices. They never held themselves out to be experts in Michigan law, and as Mr. Becker stated, it's the judge's role to instruct on what, excuse me, on what the law is, and it was the expert's job to provide opinions based on how they applied the facts in this case as they have been presented thus far to reliable principles and methods. And I believe that they did that. So, and I believe that the fact that they did not testify based on what Michigan law is, that more so would perhaps go to weight to the extent that it does not agree with what I instruct the jurors on. Also, it's ironic that he cited a Supreme Court case because obviously the Supreme Court is the court of the land, and the experts were testifying based on generally accepted police practices nationwide. And so, given that, I don't believe that their opinions or the fact that the juror heard those opinions would rise to the level of prejudicing the defense or the defendant to the extent that a mistrial should be. That I should declare a mistrial in the case. And as far as the directed verdict motion, obviously, as everyone, well, all the attorneys know, that a directed verdict of acquittal is only appropriate if after I consider all of the evidence presented by the prosecution in a light most favorable to the prosecution, I would have to determine that no rational trier of fact could possibly find that the elements of the crime charge were proven beyond a reasonable doubt. In this case, there are essentially 3 elements. The first is that the defendant caused the death of Mr. Lyoya, that Mr. Lyoya died as a result of a gunshot wound that was fired from the defendant. I believe that is obviously clear. It's on video. No one is disputing that the defendant caused the death of Mr. Lyoya, at least not any of the witnesses that I've heard so far. So it seems clear that that element has been met. Also, that the second element is that the officer had to have one of 3 states of mind: that he intended to kill, intended to do grave bodily harm, or knowingly created a very high risk of death for grave bodily harm, knowing that that would be the
Yeah, I don't think it survives a directed verdict, but definitely a mistrial.
If he put a gun to the back of someone's head and fired a round into their head, that would likely, that at least created a very high risk of death, if not evidences an intent to kill Mr. Lyoya. So I believe that element, again, would be difficult to dispute given the background of the defendant as testified to thus far, as well as the video. That brings us to the only element in the court's view that is really in dispute here, and that is whether or not this killing was justified. It's clear that Mr. Lyoya appears to have possession of the defendant's taser at the time that the shooting occurs. But it is also clear to the court that a rational trier of fact could find that the alleged victim, in this case Mr. Lyoya, was not in a position to use the taser at the time that the shot that killed him was fired. I believe that a rational trier of fact could find that based on the video alone, but if you also incorporate testimony of not just the experts, but also other witnesses, including the witness that talked about the taser, Mr. Childs, I believe a rational trier of fact could find that the killing was not justified. And so, because that is the position of the court, I am denying the directed verdict of acquittal for those reasons, because I do not believe it to be appropriate under the circumstances. And so with that, is the defense ready to put on their case issue?
We are, Your Honor, and I had a question. We were at the stipulation that came across court's preference on the stipulations in front of the jury, or should we just do those right now and then we can move right into
You mean stipulation to admission of exhibits?
Yes, and our first witness, of course, where is our video analyst, and he's going to be playing all the videos. So the stipulations that we're looking for are defense exhibit C, C1, C2, C3, C4, and then videos J and K, and then an audio defense exhibit HH.
Okay, I think these are all kind of similar videos I mentioned.
Okay, C was already admitted to stipulated to at the beginning of the trial. So because there's no objection to the exhibits that you just listed, I'll state for the record that C1, 2, 3, and 4 are admitted. I'm assuming they're separate exhibits from C. Also, I'm admitting J, K, and HH at this time.
Yeah, you're right, so it's HH, 2 H's. I don't know if I made that clear. Okay, sorry. I don't do that well.
All right, and I also received the defense witness list, so I have that printed out as well. So
It's
we'll
interesting
have
that she gives the jury witness list.
And anything else? Or
I don't know how I feel about that. Giving the jury a witness list. When she gave it to him the first time, when she gave the jury the state's witness list, she said, these might not be all the witnesses. They might not call all of the witnesses on this list, and they might not call them in this order. But that's not my problem. My problem is that they then have a list of witnesses ahead of time that may be called, or or might not be called, and so they're thinking, oh, well, we got. I mean, is it just their names? I don't know. The jury has notepads. They can write down a witness's name. I don't know why they need a list of them. I don't get it. Are they? Yeah, they're allowed to take notes. They all have notebooks, Stephen. So I don't know why they need. I don't know why they need the list. I don't like the list idea, because like Professor S, right? So Professor S. Let's say it has his full name and it says Professor S, expert on da 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 da. Well, there was a Daubert hearing about allowing him to testify. What if he didn't testify? That could be prejudicial, the fact that there's a Professor S, an expert in something, and on the list, and they don't hear from him. I don't like that idea at all.
No, I mean, I
And it could go against the defense too. So let's assume the defense has a bunch of witnesses.
And then they don't say they name an occupation, and all of a sudden the defense says, "Oh, these last two cops, we won't call them," and then the jury all of a sudden would be, "Oh, why not?"
Yeah, they're going to be in a position to read into things that they otherwise wouldn't have access to. And this is a poor decision by the judge.
Yeah, I do not agree with this at all.
And right after they come in, I'll have my clerk hand out.
Mr. Jingles, do not talk with the clause, please.
Getting ready to put the defense first witness up. I got to find just a little bit more productive of a way to work while streaming. I am working, but if I can get just like 20% more productive with work, I could do this a lot more. My chat is confused by here. Yeah, I see that.
I'm just going to come around and hand out the defendant's witness list, much like the prosecutor's witness list. I also do a list with names, with space for notes if you'd like to take them.
Let's give them a notepad and a pen, Judge. They can write down a name like I'm about to do.
Yeah, I mean, notepad, pen, and they ask, "What's your name? Please spell your name."
And sir,
There's no need for a witness list. Yeah, I really am not happy about this.
I think he needs to be switched over to. Is that what, this one? Should be. Thank you. Good morning, Mr. McFarland.
Good morning.
Now I've been referring to you for most of the trial, and you've been sitting back there, correct?
Correct.
All right. So you're a video guy.
Yes.
What's the technical term for what you do?
Forensic video analyst.
Okay. Can you tell us a little bit about your background?
McFarland.
Yes.
I
I was in the Air Force
Zoom
for
guy.
about 8 years as a security policeman. From there, I served at the Oakland Police Department in Oakland, California for about 12 years. And after that, I've done litigation support at a law firm. And for almost the last decade, I've been doing forensic video analysis.
Okay. Tell us about your education and training.
I have a bachelor's degree in criminal justice management. I have almost 200, possibly more hours, 200 hours of training from an organization called LEVA. That's LEVA. It stands for Law Enforcement and Emergency Services Video Analyst Association International. And this particular association focuses on audio and video forensics for people in that specific field. I've attended their training. There are 4 levels. You attend level 1 and level 2, similar to Sergeant Batchelor, who was here. You get a certification of a video technician. And then since then, I've attended level 3 and level 4, which is the final level of their particular training. And from there, you go on to get certified by the organization.
Okay.
As a forensic video analyst.
Qualifications as an expert.
Thank you, Mr. Bucket.
you want to have them listed in the jury, or would you like to simply be recognized as an expert?
I think we would ask if you recognize it as an expert, Your Honor.
Okay, expert in what field?
Forensic video analysis.
And you have no objection? Correct. Okay, so you shall be considered an expert in that field.
Okay. So, Mr. McFarland, you were asked to do work on this particular case. What was the scope of your work for this matter?
I was provided with the cell phone video that we've watched, the dash cam video, and the body-worn camera of Officer Schurr. Those 3 videos were provided to me. I was asked to put them on a screen as a multiplex sort of 3, all 3 at the same time to synchronize.
I feel like this guy testified already. I feel like we got the testimony about this is the guy who synchronized all the videos that the defense was using.
Them so that the actions in the videos match, so you can see, and I'll point out those synchronization points. In addition to that, I was asked to create the same sort of matrix, but do a subtitled sort of transcript alongside for the words that were spoken that I could capture on the synchronized video. From there, I was asked to create a couple slow motion, maybe one slow motion exhibit and an enlarged or magnified cell phone video exhibit. And the last thing was dispatch audio file.
Okay. And you mentioned a synchronized exhibit. Tell us how you create the synchronized exhibit.
With that exhibit, there are three videos. I decompile or export each image individually as a bitmap file. Each image is a large raster file. It has a lot of information in it. You take all of the images out of each one of the video files, and then I number them. I label them so we know what camera the particular videos came from, and then I recompile them back together. I also exported the audio files from each of the three, put them into an audio program, and synchronized those three audio files and put them back into the matrix so we have the three videos that play at the same time and all three audios.
Okay. So let's pull up the synchronized video, which is Defense Exhibit A. And it's one that has already been admitted and the jury has already seen. And before you start anything, I want to ask you some questions about Defense Exhibit A. We've been talking a lot about RFN as sort of a way to bookmark particular parts of the synchronized video. What does RFN mean?
RFN is a relative frame number. With each video, as you see the dash cam videos on screen, there's what's called an AFN, which is an absolute frame number. For instance, the very first frame you see is number 1. The very first relative frame for the overall matrix is number 1. If I scrub forward just a little bit, I'll show you. We have an AFN that's on the dash cam. That's the absolute frame number for the dash cam. And down here on the bottom, we have an AFN for the cell phone video. So the reason we have an RFN is that when you look at this matrix, you refer to this as sort of the index or a bookmark for the particular video.
And how many RFN relative frames are there in 1 second?
In 1 second, this particular video, 30.
30. So 1 to 30 is actually 1 second, but it's broken down 1/30th at a time.
Correct. Each image is 33 1/1000ths of a second.
All right. Can you show the jury a couple of synchronization points to show them how you did this?
Sure. One synchronization point is the time when Mr. Lyoya closes the door to his car.
That's Mr. McFarland. If you could continually reference the RFN number.
Yes. So I'm going to first, because the purpose of this type of tool is to use it as sort of an analytical tool. It's tough to watch everything all at once. So you want to watch one video and then the next, and then the next, and then you'll want to watch them all together. So right here, if we look at RFN 3103 in the dash cam, you see that in the center of the image, the light from Officer Schurr's car glinting off of the door, the driver's side door that Mr. Lyoya is closing. I'm going forward a single frame at a time. And there we see it at 3107, it's closed. So if I go down.
Old Jock.
Oh,
it's still open.
Champion double ale.
3108, it's closed.
From Scotland.
And the image below is closed. And so when we take it out, you can see.
If you're wondering, I'm having a day off tomorrow.
And closed.
So I'm having beer.
Get a weird communist.
There's another synchronization point with the action of Officer Schurr's foot, his right foot. And I'm at 5733, I believe. Let me find it. Just a second, looking at my notes. So it's right here. When we're at 5756, we inch forward, and you look at the cell phone video, and I'm going to bring that in so you can see what I'm talking about. You see Officer Schurr's right foot. I'm going to back it up, and then I'm going to move it forward. And right here, we see his right foot is underneath Mr. Lyoya's left leg. If I go down and that is RFN 5760. So I go down to the body worn camera and back it up. You see his foot disappears just because it's off the image. When I inch forward, we see it's in place at 5761, 5760.
Okay, thank you. That was very interesting, but what's the point of doing the synchronization as a forensic video analyst?
When you do a multi-view, you want the people who are viewing what you have on the screen to understand that it's synchronized, that you're not just throwing 3 videos up there and playing them and hoping that they can understand what's happening. So you synchronize the dash cam with the body worn camera, and then the cell phone video was only on for a short time, but I was only able to synchronize that with the body worn camera. And so that shows that all 3 have synchronization points.
And what's the benefit of having synchronization?
It's a multi-view, sort of give you different angles of the incident. Because when you look at a video, you're looking at a 2-dimensional image of a 3-dimensional incident. When you have multiple angles, you can see what's occurring from different camera angles at the same time, simultaneously.
Can you give us an example of what you're talking about?
Yes.
I do like the way this camera, these video syncs was set up. It was really kind of interesting to watch. We've seen it a couple of times. Why zoom in on the date, man? Get the whole freaking thing. This cameraman.
Here's an example. So on the RFN
hey,
4696.
Good to see you.
I'll zoom in so we can see what's happening here. We see Officer Schurr on the back of Mr. Lyoya. We see his right arm over Mr. Lyoya's right shoulder. And it's tough to tell because it's at a distance and it's a bit pixelated. But we see sort of the same thing. But when you back out and you look at it, we also see in the distance, I believe that's Fred Butler in the white T-shirt. He's got his arm extended and he's pointing. And if I inch forward, you see the movement of Officer Schurr's left elbow.
He's not living up to the
so I'm going to go back.
generally accepted cameraman practices, right?
To 4703, and I'll continue to go forward. And we see in both of the videos,
kind of want to
the left or the right arm of Mr. Lyoya come up. I can go back and forward. And then if I play it, we're at 4726. You see them both up and standing at 4810.
Okay, you did that. You watched all the videos in synchronized format and analyzed it pretty much frame by frame. Right?
Correct.
And you also created a synchronized exhibit that includes a transcript.
Yes.
Now tell us how you created that.
It is the same video, the synchronized video. I just added a section of pixels on the right side of it, and I had the audio playing in a separate program. And when words were spoken, at the time the words were spoken, they started to be spoken, I would put the sentence or the phrase into the video itself as the subtitles of what they're saying, so that the statement starts as on the screen, starts at the same time.
Okay. And this has already been admitted as something to the B, Your Honor. If you could go ahead and play that video start to finish.
Yes.
At normal speed.
Yes.
Nelson, 4 degrees, Edward King Hall, 9367, Hamilton. Hey, stay in the car! Stay in the car! Stay in the car! Get in the car! Dude, I'm stopping you. You have a license? You have a license. I'm stopping you. Do you have a license? Do you have a driver's license? Do you speak English? Yes. Can I see your license? What kind of license? The plate doesn't belong in this car. Do you have a license or no? Do you have a driver's license? Yes. Where's it at? Get it from. The plate does not belong in this car. No. Stop. Put your hands up. Stop. I keep it. Stop. Okay. Stop. Stop. Get your hands behind your back, okay? Hands behind your back, okay? Your hands behind your back. I can take it. I can work hard. Stop. Stop resisting. Hey, good enough. You see nothing. Let go of the table. No, he's good. You can talk to him. Right? Like good, bro. Like, can you talk to him like good, like him? Talk to him like that. No, he's good at first. No, you hear him too. Now he ain't got no taser. I'm sure. That's it. Did you get how many years you got going? Everyone. Get his hands up, those are great. Get back! Thank you, Jesse. Over shooting. That'll be great.
1915, 10-4, Nelson Street. Sorry, Michael.
Thank you, Jesse. No, no, nothing great, nothing before. Don't look down.
Nelson, 10-0, North Street. Nelson, North Street, suspect down.
1920, 15 Roger, subject, the access anyone to the one-way lane. 1950, have my taser.
Okay, his partner complied.
1625, 10-4, there's one more. There's only been one. They're staging until we figure it out.
I got the car on the driver's side.
You have now seen heading to the north off Holville. 1918, let's make your cover.
1918, Holville. 1746 and 1752. Keep all those two residents information over the numbers.
Why are we zooming in on commands 31? Cameraman, settle down.
Yeah, but
Back up and give us the evidence.
Yeah, the evidence. And there the other cops are. So, but did they reply? Because he had to phone it in. Cops were on their way.
They showed up so quick after the shooting, but he did, I think, radio for backup when he first got out of his car.
Yeah, and probably when they heard shots fired, they stepped on it.
Yeah.
We've seen it several times by now. You see Officer Schurr in his car because his body cam goes on, but there's no sound.
Right.
Explain why that is.
The Axon Body 3 at this particular time had what's called a pre-event record buffer. And what happens with that is your body-worn camera is constantly buffering. It's capturing images. When the officer activates the camera, that only activates the audio, but what it does is save or preserve the last 30 seconds of images. So when this camera right here is on, he actually didn't activate it until 30 seconds later. These are images that were in this buffer, so to speak, for 30 seconds.
And you created this transcript. Are you the one that created the transcript?
Yes.
You use headphones to listen the best you could, but you understand the jury is the one that decides what is actually being said.
Correct.
This isn't a certified court reporter transcript.
It is not.
All right, so you made some smaller videos related to the cell phone. That's Mr. Tuyasheme's cell phone, right?
Right.
And those are C1, C2, C3, and C4.
Yes.
Why did you do that?
When you look at the matrix or the three videos on the screen at the same time, you can see the cell phone video is sort of long and tall and distant. And the reason for the creation of the cell phone video is to crop the top just because that's where all of the action occurred. Nothing happened in the lower half of the cell phone video. So I made that so it could fit on the screen without continually zooming and in and out and such. Also, that
like the cameraman
the other two exhibits were the motion tracking for the taser wires and or the probes. And then the final one was the part of the incident in slow motion.
Okay, well, so let's start with C1. This is the crop image. Could you play that for the group?
Yes. Oops. So this is the first frame. Up here on the left, I put the RFN number just because we've been relating to the RFN number and everything. This is the RFN number where the cell phone video lands in the synchronized exhibit.
And what is that number?
The RFN number 4146, I believe.
And that's when the cell phone video starts?
In RFN 4146, correct. I'll play it.
Yeah, Ben, you good like that. Don't bring him like that, though. Yeah.
Well, he didn't get back in the car, so I'm assuming it was a no.
No, he said he's good for me. Yo, what's up, man?
He disobeyed every order given.
Stop, okay? Stop resisting. No, he's good, not resisting nothing, bro. Okay, why you gotta do all that, bro? He good, man. Let's go on the taser. Let's go on the taser. No, like he good, like you can talk to him, bro. Like he good, bro. Like can you talk to him like good, like can you stop grabbing him like that? No, he good like for yo, you hear him too. No, he ain't brought no taser. I see that.
Hey, Aaron and Olivia.
Stop taser. Get back.
I have these last moments.
You know, this last time I watched it, and I don't know if it was because it was slightly sped up. Maybe that's what it is. But I don't know. Maybe it is self-defense. I really want to hear the officer testify. I'm still going to need the officer to testify.
Yeah. The sad part here, it's all so unnecessary.
Yeah, all of it.
My guess is that these streams will have a hard time keeping the monetization.
My one from the other day did pretty good. I think it stayed green.
I had to appeal for it to become green.
We made additional videos from that video. Exhibit C2, can you tell us what we can see?
I'm still green.
Yes, this is the last part. This is a segment of the cell phone video. It is
yellow.
That's awesome.
Yeah, I think before I publish this stream, I have to.
This is 6 seconds in length. It's the last portion prior to the shot being fired.
Every other stream is green or yellow.
And now there's a yellow
box. Yeah, that's from that position going forward. That is what I'm having a hard time with.
That particular portion there, I magnified what you could see in the smaller box in the video, and that was to capture the taser in the hand of Mr. Lyoya.
Yeah, I don't think that is what the jury is focusing on here, because here he clearly is not being held on to. He's on the back of the suspect. And right after that, he pushes it down, draws his gun.
Is it the same speed?
Yeah. Sorry, folks.
Slow motion.
Okay. So
5 frames per second.
Right, so the difference is the speed of the play.
Yes.
Oh, they're looking at his hand. You see that?
Yeah.
Where the taser is? Oh, there it is. It's in his right hand now.
Yeah.
He got it from his left hand to his right hand. The officer was not in control of that taser at all at this point.
And again, this stops prior to the shot being fired, about 15 frames or half a second.
Okay. And, we neglected to say the RFN numbers.
Okay.
But does
I don't know. I'm just thinking.
Does the cop see that?
If someone takes a weapon off of me, and they're doing it in self-defense, but then they continue to handle it, I might think that they want to use it on me. Right?
For both those exhibits are RFN 7407 through 7602.
I got to call the.
And then there's a C4.
Yes.
What is exhibit C4?
This is just the full length with no motion tracking. It just runs the length of the incident. Oh, I guess it does. So it's a mixture of, it has the taser wire motion tracking, and it also has the magnification part where we point out Mr. Lyoya in possession of the taser.
Well, let's talk about you said it's a taser wire motion tracking. What do you mean by
good
that?
If I leave the video playing for
I put the video in my forensic software, AMP5.
What?
And I circled the.
Sorry, I said, are you good if I leave the video play for a few minutes while I call the court? Not this court, different court.
Images where the taser probes were present and they were being dragged across the lawn. And it's motion tracking is what is considered when you do a single frame advance and you keep that circle over it and you go all the way to where it's no longer useful, and then you back it up and you put a different circle around the other one and you do the same thing. And then when you play the video, those filters are applied over the video to show you where those taser probes are going.
Okay, and this program that you use is called AMP5, is the same one that Sergeant Batchelor uses?
Yes, AMP is just the word AMP, and 5 is FIVE. It's an acronym for Forensic Image and Video Enhancement.
Well, we want to see the whole video again. Can you just go to the part where you just referenced with the wires and the motion tracking?
Yes.
And reference the RFN number and then tell us what you're seeing here.
Okay, we're at RFN 5719. The yellow circle, it's kind of hard to tell now, but it's encircling one of the probes. And the reason I knew that that's where it was is because I watched this enough times and watched it go across the grass that I had to back up to where I first could see it and circle it. And then I can inch forward from RFN 5719 and you can see it move across the grass. And then you see the blue circle come on, and that's another probe, same sort of motion tracking. And I follow that as they both are.
You could stop for a second and back up 2 frames. And 3.
I think this pinch and zoom sort of technology might actually work for the
Gray
defense.
white thing dropping down. You know what that is?
Gray white thing.
Is it rain?
Oh, yes, those are raindrops.
So this is slow enough. You can actually see the rain coming across.
Yes,
the lens.
sort of motion blur, but you can see the raindrops as they're descending.
Raindrops keep falling on my head.
You could also see in this on Officer Schurr's right leg, and I'll zoom in a little. Those are the taser wires. I'm not sure who they're wrapped around, but those are the wires of the taser going across Officer Schurr's right lower leg. And I can inch forward. Now we can see that they're look to be to the around Mr. Lyoya. And we continue forward 5741, and we can see the probes move 5754. I lost the blue one momentarily, and I picked it back up at 5775, and I'll just inch forward and you can see the probes move. We are
I'm not sure.
They seem to be sort of stable.
I think the officer attempted to deploy it once,
Closer together at
and then
5809.
Lyoya deployed it a second time.
That's sort of where they end up. 5827.
Now you analyzed all these videos. And you looked at them many times, I assume.
I did.
Okay. And you were able to find significant points like this, where the taser wires, you could actually see them sort of bouncing across the lawn.
Yes.
All right. You have the ability to take still shots and create exhibits on the stand, correct?
Yes.
All right. I'm going to ask you to do that as we go along. You don't have to make the exhibit now, but if you could, we could just say we're going to make an exhibit now and then make them all later. And can you put that in a file, and then we'll ask the court to move it into evidence?
Yes, I would do sequential images.
Okay. And we're going to start with the majority of the moments that you're going to capture. Is it from a particular exhibit, A, B, or C, or?
I would say that the best exhibit is the one with the transcript.
Okay, and that's B. So when I call out an exhibit, I'd like you to note that RFN for the record, explain what's on there, and then we'll identify it.
I'm so glad this
I'll
is
move it in for admission at completion of your testimony.
Okay.
All right. And now you saw significant points. Obviously, it's not that long of a video, relatively speaking, right?
Correct.
But the advantage of blowing things up is to show the jury things that is not readily apparent from just watching either the cell phone video or the body cam.
That's correct.
All right. I'd like you to go to RFN 265. It's basically the start of the video. And play that to about 3:14. Tell us what's going on here.
Okay. So 265. This is the part of the incident where Officer Schurr is making just about completing a U-turn to pull in behind Mr. Lyoya, and in the distance,
Zooming in on the date.
where my arrow is pointing in the dash cam, almost in the middle of the dash cam image, we can see a car, and that car is Mr. Lyoya's car. And if I play it forward, you can see the car move and also Officer Schurr accelerate. And I'm sorry, where did you want me to go to?
3:14.
Okay.
That's not very long. Either.
No.
If you could mark as exhibit, just to be safe, we're going to call this B3. And if you could back it up a little bit so you can see Mr. Lyoya's car. And that would be RFN 269. That's going to be exhibit B3.
Okay.
And then further on the video, Mr. Lyoya takes a second right turn. Can you go to that around RFN 499?
Back up here.
Go ahead and play a little bit.
So we'll start at RFN 492. On the right side of the dash cam, you see brake lights. And this is Mr. Lyoya's car down the street a little bit, and I'll play it.
Oh, this is what we wanted to see.
And at 6:96, Mr. Lyoya completes the right-hand turn.
Okay, we can mark that as.
Yeah, when did you put on the lights?
Yeah, we want to know when you turn the lights on.
And I think we'll go forward to Officer Schurr, calling the stop out and Mr. Lyoya exiting the car.
So this is right about.
I don't think the lights are on right now.
RFN 1020. And what you'll
I
see
don't think
here
he put on the lights until
in the
he
dash cam or the body-worn camera video, you
went out
see,
of the car.
Yeah. I
So
don't
is
think
it
so.
really a lawful stop?
Well,
Or did
I mean,
it just happen to be behind them when they pulled over?
so the testimony, if you guys didn't notice, or if you weren't here for it, is the testimony from the friend, the passengers, that the car was making noise and Lyoya stopped it and got out to check on the vehicle. And then you just happened to see the cop there. And that's why he got out of the vehicle. And that's why he might have been confused when the officer gets out of his vehicle and yells at him to get back in right away, because the officer's thinking he's making a traffic stop. Lyoya thinks he's getting out to check on his car and wondering why a cop is yelling at him.
Yeah.
So that probably started the whole thing off on the wrong foot. So Nick and I's question is when did the lights turn on? When was there an actual, stop?
We know the cop saw them because he knew that the license plate were wrong.
Right.
So he had time to check it, notice, check it, and follow them.
Yeah.
But if the lights aren't on, he's not actively stopping them.
Right.
And from what I see there, he did not turn on the lights until he stopped the car.
Yeah.
And by then, they had already stopped.
Yeah.
So is this an actual lawful stop?
It's lawful law for sure. My computer's.
We need input from Mr. What's his face?
Oh yeah, Derek or not. What's his name? Yeah. I can't remember his name because it doesn't matter because he's in prison for the rest of his life.
Yep.
Zach with the 199 super chat. Monetize now. What a grifter. Yes, thank you, Zach.
Yeah, he's getting more. I have obliged with the rules. I haven't pissed people off. And you super chat him.
And Derek, the super sticker of a dancing chicken, it looks like, giving a thumbs up for 299 pounds, right? Is that what we do? What happened? Where'd you go?
But you will have the chance on Friday on my birthday stream, where I will have a lot of guests and the Wheel of Regrets.
Nice.
So hold it in. Do these sympathy super chats today and save your big money for Friday.
I'm good with that.
Officer Schurr's hand coming up across toward his face with a police microphone in his hand, right hand, and Mr. Lyoya exiting his car.
Nelson from the Grace, King Hall, 9367, Hamilton. Hey, stay in the car!
And we're at RFN.
The dancing pair. All right, it might be a dancing pair.
Yeah. But again, the prosecution doesn't actually go
Officer
with
Schurr
it was
getting
not a
out of his
lawful
car,
stop.
right after Mr. Lyoya exited
You
his
should
car.
invite Farrell on. She's gonna be home.
I have invited Farrell.
Oh, nice.
So, Dave, can you just be in the background, do you think? So you don't,
Stay in the car!
you don't scare off
Get in the
Farrell.
car! Get in the car!
I promise I won't be on there with you.
I'm stopping you. You have a license? You have a license. I'm stopping you. You have a license.
Oh,
You have a driver's license. Do you speak English?
Snidey Pie over at Rumble. Thank you for your
That's your
$2 Rumble rant. Thank you.
We
So I get
can't
Rumble rants. But Rumble takes 50% of my revenue. Because I don't have that, what you call it, I don't pay for Rumble. So they take 50% instead of 20%. So I'm not entirely.
Well, in between. Okay, so he doesn't just stop his vehicle to check on a noise and ends up getting shot. There was a little bit in between there. There was a little bit of fighting with a cop. There was a little bit of running from a cop. There was a little bit of taking the cop's taser. you know, those sort of things was.
Yeah, normally occurrence is apparently according to the prosecution.
Yeah.
Thank you, Zach. Thank you so much.
Yeah, now stop whining, Nick.
The plate doesn't belong in this car. Do you have a license or no? Do you have a driver's license? Where's it at? Get it for me. The plate does not belong in this car.
So I'm going to pause here at 2737, and I'm going to zoom in on the body worn camera. And at the near the B pillar of the car, there's a hand that is the right passenger. And as I inch it forward, you're going to see he right there opens the glove box, and the glove box is open at RFN 2807.
Can you toggle back and forth so we can see the glove box open and close?
Yes. Close. Open.
The order's open, close, right? Not close, open.
Oh, I just reversed it. Sorry.
And so could you find an RFM where you can see Mr. Tushev's hand on the glove box?
Yes. RFN 2759.
That's going to be D6. If you could go up forward to the point where Mr. Lyoya breaks away and shoves Officer Schurr.
Yes.
Like the pause with the fist up. Looks like
Okay.
he just
RFN 3317.
Okay, and what do you see on that?
You see the clenched fist of Mr. Lyoya, his left fist. You can see his right hand, and you see Officer Schurr holding the left and right wrists of Mr. Lyoya with his left and right hands.
Okay, you can make that D7. What was the RFN 3317?
Yes.
If you go forward to the point of the breakaway.
Okay. I'll play it and then come back.
Okay.
More or less right here to 3349 where he's completely free.
Okay. And is there any point where you see Officer Schurr be shoved backwards?
Yes. So I'll go back to 3317. And then I'm going to single frame advance the images. So if we advance to 3318, we see the right hand of Mr. Lyoya come closer to Officer Schurr's body worn camera. Then his right hand breaks free from Officer Schurr's right hand. And I'm inching forward. At 3329, Officer Schurr grabs the right shoulder area of the sweater Mr. Lyoya has on. And you can see in 333, Officer Schurr's hands are now sort of crossed in front of him. And you see Mr. Lyoya's arms and hands are up in the area of the forearms of Officer Schurr. And as we inch forward to 3340, we can see the knuckles from the right hand of Mr. Lyoya over Officer Schurr's left forearm. We can see Officer Schurr's left hand making contact with his right forearm. And then as we continue forward to 3344, we see that Mr. Lyoya is completely free. But if we back up at the point of 3340, this is right around, I'm going to go back to 3338 and single frame advance and just pay attention to the dash cam.
Terribly confused as to what frame.
Officer Schurr, both feet are off the ground. And I go back.
What?
And you can see Officer Schurr stop right there. So you toggle this action.
Both his feet is off the ground.
And you saw what happened in the body worn camera, but now you have it from a different angle. And I toggled that section 3345 to 3345.
You said you toggled 3345, but I think you said 3345 again. When you say toggle, you mean you're moving frame to frame.
It's 3338 to 3345.
They're saying Lyoya is jumping off to the side. Mads with a 20 Danish crown super chat. Thank you. Michigan looks at jury as Sweden. It is actually Michigan is very similar to Sweden.
Yeah, it is. It's very, very similar to Sweden.
Yeah, climate and
you should have more mountains though.
We should. You should. It's supposed to be Sweden, like land of the mountains.
Yeah.
Yeah. By the way, Farrell sends me a question on Twitter like 10 days ago. I answer it 10 days ago, and she's just now getting back to me. Yeah.
Really? I sent her an invite yesterday, and she answered within hours. It's almost as if she likes me more.
But don't ask me a question then. You know what? I'm not going to answer your questions on Twitter. This is your super sticker, by the way, from Eric. What'd you get? What'd you get? What was the super sticker?
The super sticker is a pair with boxing gloves. With boxing gloves.
No. You got a cheerleader with pom-poms.
Okay. No, I'm quite sure it's a boxer with boxing gloves.
Okay.
Don't you read in things that aren't there? I don't want to be in your. I prefer to think about boxing. You like pom-poms.
I'm just reporting what I see. That's all.
Mark 3338 2345 as B8.
Okay.
Okay, at this point, you also have a timer, and it's in the bottom right of the exhibit B. And it keeps time to the second, and then it's 8, 12, 55, and you have 0.403. Now, we're not used to even the 55. Can you explain to what degree of accuracy the clock is?
So the 403 is milliseconds. Because there are 30 frames in a second, when you watch a video and you say, I'm stopping the video at 3 minutes and 55 seconds into the video, the question becomes, well, which one of those 30 images did you stop on? So that's the reason for the numbering, but also for the millisecond. If you wanted to understand timing, you would understand everything right down to the millisecond.
Okay, and you were asked to figure out some timing, and you were asked how much time it elapsed for the time Mr. Lyoya exited his car at this point right here in RFN 3338.
Yes, that was approximately 1 minute and 10 seconds.
Everyone needs to go step to lefty.
Pass the chase to the point where Mr. Lyoya first gets to his feet.
Definitely.
Okay. We're going to RFN 3582, and I'm going to zoom in on the dash cam. And you can see the toggle forward and back. You can see that the legs and feet of Officer Schurr up in the air as he's on the back of Mr. Lyoya. And they're both appear to be facing northbound.
That direction's north?
Going toward from the back of the car, Mr. Lyoya's car to the front is north.
You actually figured that out?
He said somebody was running northbound.
Oh, okay. All right. And so I think it toggle forward, play forward to 3778.
You can't see the
when the holy roller neighbor comes out. That guy was awesome.
Okay.
So it was about right here. 3778, and I'll zoom back in on the dash cam video. And you can see Mr. Lyoya's up to his feet.
Okay, now what the R31?
3778.
And you previously had showed us in the dash cam video, Officer Schurr's feet were in the air and they were heading north.
Yes.
Do you recall what RFN that was?
The first one of this,
Yeah, I forgot to ask you.
that would be 3582. Let me go back and make sure.
Okay, at this point, I've got to object on the relevances. They can play around with the video as much as they want in the jury room. So I mean, I was given the leeway. I don't know what we're doing. It's not published in the jury. Things that the forensic cameras have seen it blown up. They won't have the ability to blow these up. Certainly the jury's.
What's your response to this objection about the relevance?
I'm explaining the relevance is.
He's playing the video.
To the jury, blown up and highlighted areas that the expert is specified. And he's explaining how he made those exhibits and I'm making exhibits for the jury's consideration so they can view the evidence. Through,
Is this in front of the jury?
Yep. Yeah, this is all in front of the jury.
Sure.
Why? They are arguing about the admissibility or inadmissibility. What is she going to do if she decides, no, you can't do that?
Well, I think it'll perk the jury's interest in the video. Be like, well, what else were we going to see? What does the state not want us to see?
Yeah.
Sure. It's up to your discretion. That's my objection. I gave some leeway. This is
Well, it's pretty cumulative, I believe, and the jury will have their exhibit, so I don't know that.
The jury will have
certain portions is relevant to.
I don't know if the jury is going to be loading up, Your Honor, or. Well, I mean, I'm watching that's up to them, but I've seen the TV. It's a box TV back there. There's full ability. Certainly, the jury at the end of the question.
There's a box TV in the back, like an old one with a
So I mean,
tube.
I'll sustain the objections. Doesn't seem like a good use of the court's time to go through each frame and blow certain ones up and making them into separate exhibits. Obviously, the jury will have access to the exhibit. They can play it as fast.
No, what is this?
Unable to see it.
This judge, by the way, she spent her first years of practice as an Air Force, in the Air Force. I think it was the Air Force or Navy. I think it's Air Force, though. Working for the U.S. Attorney General. Then she went and got a job at the prosecutor's office. Then she was working for the Michigan Attorney General. And then she spent a few years in private practice before she became judge. So she's very, very much of a prosecutor's mindset.
Yeah. But all of this in front of the jury?
Yeah, I guess. Yeah, unfortunate pause face. I know. I saw that too.
We are experts at pause faces.
May I just make a record of the ones that we're going to blow up and move into evidence? Well, there's much less than the thousands that the prosecution has entered into evidence.
Well, I don't recall them doing thousands of blown up images.
They went through and published some of the thousands that I think said it was about 1,000.
1,000 what?
Images. That's their exhibit. He broke down still frames, and then he's been calling them out through the testimony.
So why can't they counter?
Yeah.
You don't recall the thousands of images that he admitted?
What?
Again, this is cumulative, and so I'm going to sustain the objection. I'm not sure that this exercise.
Take the jury out. Take the jury out.
Your Honor, my client has a right to present a defense. We believe that includes analyzing the video in front of the jury. We're far away. If these things need to be blown up, they're not going to have the ability to blow it up. I think they're entitled to see what Mr. McFarland's work has been done. There's no objection to his qualifications. There's no objections to the exhibit. But I would like to make additional exhibits that we believe are important to the defense of my client. If the court's not willing to let me publish them now, I would like to be able to enter them into evidence at a later time. I can recall Mr. McFarland without publishing them to the jury. And that would save some time if that's the court's concern.
That is my concern. It seems like it's very
It's not cumulative for the defense.
I'd like to pull up certain parts of, because it sounds like you're creating an exhibit as we're sitting here with video. And I don't
Yeah, you can do that.
Something your client has a right to do, create.
What the frick is going on?
No, they absolutely can.
With your witness creating additional exhibits that go along with this one to blow up the areas that you like for them to without.
This is testimony regarding the video.
Okay, Ryan, what I'd like to do is,
and it's expert
at the same
testimony.
time, we'll have our coordinated, and then we can always recall Mr. McFarland and the jury if they want to pass a note that we'd like to see this part blown up or something. Certainly, that's something.
Oh, he suggested to the jury. Good one.
But that was great.
And that's a good one.
Like, hey, jury, if you want to see more of this, just let us know.
Yeah, that's what's a switcheroony.
That
doing all of that in front of the jury, and yeah,
I'm here for it. That was so improper.
Yeah, okay.
They're not going to have unless the court is going to allow us.
Again, I'm not saying you can't put those exhibits in, and you're creating the exhibit to take stock of this, go this in the frame, oh wait, go back, I think I forgot which one we were at. So he's creating the exhibit on the fly right now. I don't have any problem if there's no objection, especially to admitting those exhibits if they're created. I just.
But there were no objection.
On the record right now. So,
She just don't want to admit this blow up thing as a.
So the objection wasn't cumulative. The objection was relevance.
Yeah.
Right? So the state objected and said it's not relevant, despite them showing the exact same videos multiple times and still frames from the exact same videos multiple times. They're saying it's not relevant. And the judge says, yeah, I agree. It's cumulative. No, that wasn't the objection. Nobody listens to anybody in this case. That's what I'm getting at.
Yeah.
The objection to the extent that it.
It's a waste of time.
Oh, now it's a 404.
Waste of time.
I don't know that it's cumulative, to be honest, since we're not taking the same picture over and over again. And so what we'll do, Your Honor, is we're at B10. We had a number.
You're already briefing this. They're going to present the written
2, 3,
motion.
4, 5.
Yeah.
6, 7, 8, 9.
First of all, it's in front of the jury. They are hearing all of this, and that's bad judging.
How excited will you be if the jury question after this witness is, we'd like to see that video?
Fair enough, Your Honor. We can do that.
Yeah. We'd like to see that blown up.
No, that's all he's doing is looking at the videos.
What's a waste of time? It's apparently a waste of time to go through the video that the state has presented on at least 10 separate occasions. It's a waste of time to go through it.
Yeah.
Exhibit HH, it's already in evidence. Can you tell the jury what that is?
This is the truncated dispatch audio. We received this audio file of the communications between dispatch and Officer Schurr and other units in the field. It wasn't received in real time. It was each individual transmission put into one continuous stream. And for that particular exhibit, I took the audio from the synchronized video file and put that in an audio program called Audacity. And then I put silence in between the transmissions to match the timing of the transmissions in the synchronized video so that when you listen to the dispatch audio, it plays back in real time.
Okay, and we'll post that at a time, Your Honor. I just wanted him to explain what it was. How long is it?
I think it's 4 minutes long.
Mind you, we said that this case is 100% on the video. Everyone's in agreement. But for the video, there is no case. So now that the defense wants to use the video, it's a waste of time.
Okay, if the court's okay with that, we'll just publish it now. If you could just play HH.
Take care, Aaron and Olivia.
Take care.
Have fun with your exams.
Yeah. Law Kong Express says his channel is still tariff-free.
Yeah, everyone go subscribe to Law Kong. I know there's a link in Nick's chat.
1913.
It should be.
Nelson and Graves.
So this is just an audio file. I thought they were going to play it over the original video or something. This is fun and exciting, Nick.
Yeah. Well, look, a traffic cone.
So we're hearing nothing right now. What does that mean?
That's the time when Officer Schurr announced the car stop, and the car stop was acknowledged by dispatch. There's silence because nobody else is providing any transmissions.
Okay, so this is only Officer Schurr and dispatch. What's dispatch?
Dispatch is the police dispatcher at the police department in the communications division. They're the ones who receive the transmission from the officers.
One running northbound, additional units now on Griggs.
I don't think there needs to be a real-time pause if it's not being overlaid on the video, like even the dash cam video or something.
Yeah, but the prosecution showed coordinated, so I don't understand what's the issue here.
1950, what's your location? What's your location?
No video, just audio for this. I wonder how long it took for charges to be issued after the shooting. I don't think it was immediate. I think there was actually an investigation.
How many cars you got going?
Everyone.
Was it the same day, really?
6 in total.
So there wasn't much of an investigation.
No.
It is.
1915. Oh, just all the shooting.
Oh, you don't know. Okay.
1915, 10-4, Nelson and Griggs. Starting medical.
I don't know how far backup was.
I'm Nelson. North of Griggs, that's 10-4. Suspect down.
Nelson, north of Griggs, suspect down. 1920, I've seen.
That was one of the things that the Detroit police chief or Detroit police commissioner was talking about, as well as Grand Rapids.
1950, that's my taser.
Doubling them up in the car so that things like this won't happen.
Yeah. Cops the size of Dave needs to be not alone in the car.
I'm big everywhere it counts, Nick.
1525 for addressing one more.
Your brain.
For addressing one more.
Remember when you said that you were a trophy husband?
I am a trophy husband, yes.
No, you're not. No, you're not. I've seen your wife. You are so lucky.
I am. Yeah. No,
Yeah.
I'm batting way out of my game even.
So I think the plan is for Mr. Capone to step down but not be excused.
So you may step down at this time, and Mr. Becker, I'll wait in the line to do cross-examination.
Yeah. You swayed her with your dad's boat and stuff. Yeah,
My personality won out.
Yeah.
I have a cross right now, so it depends on what you present with this exhibit for this one. I have a cross.
No cross.
Then you may step down too.
Wait,
No
jury
cross.
questions?
Jury question. Can we see it?
Not ready to call someone right now. We should probably have about a half hour.
The trial is
Yeah,
fast.
because he's not ready to call another witness because you cut him off at the knees, Judge, by saying like he couldn't introduce irrelevant evidence, which is the exact same evidence that the state's been using the entire time. So
Yeah.
I don't know how it's irrelevant and a waste of time, but that's what you did, Judge.
Yeah.
That's about how the case has been going
Yeah.
so far. But thank you for joining us.
Yeah, we're on day 3 and the defense case in chief. And folks, this is actually normal. Trials usually are not longer than this.
We gotta kill like 20 minutes of airtime.
Really?
Yeah. Because they go on break. And he just said that they're not ready for their next witness for a half hour, and we're 10 minutes behind.
Oh.
Hour-long break? We have an hour to kill. Do you want to set up an afternoon stream?
Yeah.
Because we have an hour from now.
Yeah. Yeah, we might as well set up an afternoon at 10, maybe.
Let's see what the judge says.
I think this is
Oh, they got a Euro question. That is fair.
Let's listen to this question.
Yeah,
In the meantime, I'm going to set up the stream.
Yeah.
Because.
Good question. The comments that are get the keys, Amy, get the keys. There were 3 comments. They had the asterisk next to them. That was there because the audio, when I synchronized the 3 audios together, the body-worn camera kind of distorted some of the sound. When you listen to those comments, they're more clear on the cell phone video all by itself. So the asterisk was there just to point out that you can hear them, but if you want to hear them better, look at the cell phone video and listen to that audio.
Good explanation. And that was the only one. Damn it. No. No. Can we watch the blow-up thing? So we have 12 inches spread and blow up in this trial.
Anyway, we'll make sure everyone's. Meanwhile, please leave your notes again upside down in your chairs.
Come back at quarter to what? Quarter to 3?
Also, remember the restrictions with respect to news reports on the media.
A quarter to 3, that is a quarter to 10 my time. That's more an hour and a half.
I'm going to set the stream up for 3:30 Eastern.
That's
so
9:30.
That's an hour from now.
Yeah.
Okay. All right. It's getting set up now.
Yep. Yep.
Just a reminder that when we were supposed to do that.
Quarter to. So don't get an hour. Just waiting for an hour.
Yeah. So we'll be back in an hour. All right. And that's where we are. That's what we got.
Yep.
I am not terribly thrilled with the rulings in this case. I'm not terribly thrilled with the defense strategy in this case. But I say all that, and I still say the guy's guilty. If I was sitting on that jury, I'd still be voting guilty at this point. I'm not terribly convinced because I didn't get to see all the video. They were just, so if you're coming in late, they were just getting into close-up video of the suspect moving the taser from his left hand to his right hand. And then we weren't able to see anything else. And then the judge ended up cutting it off on an objection of relevancy to the video that the state's been using for the last 3 days. Is all of a sudden no longer relevant because the defense is admitting it.
Yeah.
So I'm not a fan of that. I'm not a fan of the defense strategy. I'm not a fan of the cross-examination of the experts. Not a fan of the allowing the experts. But I still kind of think he's guilty.
Yeah, that what might save him, because I've seen this in another trial where where the jury said we wanted to convict, but according to the jury instructions, we couldn't. And that was kind of surprising because that was a jury that actually noticed what can we actually rule on.
Yeah, I'm with you, Dark Lotus. I'm still leaning towards guilty. That video is bad. I know what they're saying. Yeah, the taser, you can kind of see where the taser might be shifting from the suspect's Loyola's left hand to his right hand. But there's still no indication that he was going to use it. I don't know. It's going to come down. I want to hear Officer Schurr testify. That's really what's
Yeah.
come down to.
Yeah.
But we'll be back in an hour. I set up the redirect to go to the next stream. Did you do as well, Nick?
Hold on. Dun, dun, dun.
Everyone, go subscribe to Lefty and Law Kong while you're at it. You're just hanging out.
Yep. Done.
All right. Well, guys, we'll see you in an hour. I'm gonna go get something to eat.
Yep.
All right.
Me too.
Bye.
Two screens light up justice calling from sweet and cold and Great Lakes falling. Educating fools, real talk streaming. Truth and laughter, crime redeeming. Raise your glass to law and jest. Trials not just pain and stress. Teach